All right, let's dive in. Today, we're taking a look at the first month of India's new Chief Justice, Suryakant, and we're going to do it through the lens of a really fascinating document. What makes it so interesting is, well, it's the very unusual way it frames his role. Let's get right into it. So right off the bat, the analysis hits you with this quote. Comparing a Chief Justice to a deity? That's not your typical legal commentary, right? But you've got to understand, this comparison is absolutely central to the perspective we're exploring here.
Okay, so just to set the stage, we're focusing on a very specific, very early window here, just the first 30 days of his tenure. And, that first month, that's such a critical time where impressions are formed and priorities really start to take shape.
Now this is where things get really unique. The analysis steps way outside the box of normal legal commentary. It actually builds this entire framework based on Hindu mythology to explain the very function of justice itself. The author makes this direct link, connecting the Chief Justice to Lord Shiva through this concept of Kalagni Rudraya. And what does that mean? Well, it represents the cosmic force of time. So the idea here is that the top judicial job isn't just about interpreting laws, it's about embodying time itself, a pretty huge concept.
And it doesn't stop there. The whole framework keeps building. As you can see, it's not just Lord Shiva representing time. You've got Lord Vishnu as space and Mata Durga representing gravitation. The force that brings balance to everything. It's like a whole cosmic system for thinking about justice.
Okay, so you've got this really deep philosophical framework, but how does that actually connect to what the Chief Justice is doing day to day? Let's take a look at how the author sees this all playing out in the real world.
And the assessments is, well, it's glowing. No two ways about it. The author makes this pretty bold claim that in just 1 month, the new Chief Justice has managed to win over the public, especially, they say, among the poor and the downtrodden.
So why the big success so early on? Well, according to this analysis, it's no accident. It comes down to this specific blend of empathy, a really focused approach, serious judicial skills, and the kind of leadership that is actively making people trust the courts again.
But it's not just about personality or leadership style. The document also lays out a very clear mission, a set of core priorities that were apparently established right from day one.
And here they are, the 4 big ones the source points to. First up, fundamental rights, like the right to life and free speech. Then, a real push for judicial diversity, specifically with a preference for women. Third, staying impartial, by strictly sticking to the separation of powers. And finally, tackling the country's biggest burning issues head-on.
Okay, so those are the priorities on paper. But what does that look like in practice? The source gives us a great example, a case involving India's election commission. This really shows how these ideas are being put to the test.
And this case really gets to the heart of a tricky question, one that a lot of countries are dealing with. What should a court do when people are worried about the transparency of a really important independent body? What's the right move? So you've got this real balancing act, right? On one hand, the source says the court totally acknowledged there was a problem with transparency. But on the other hand, they were really careful not to step on the toes of the Election Commission, to respect its constitutional independence.
So what did they do? In the end, they decided to step back. Instead of the court forcing a solution, the message was pretty clear. This is a job for the legislature. It needs to be solved in the people's parliament.
All right, so let's wrap this up. When you put it all together, what's the big picture this analysis is painting of the Chief Justice's first month? What's the main story here?
Well, it really seems to be a portrait of balance. The source describes a leader who isn't just sitting back, he's actively trying to solve problems and build public trust. But at the same time, he's also really aware of the limits of the court's power. He respects those constitutional boundaries, just like we saw with that election commission case.
In the life of any big institution, you get these little tweaks, these small changes over time. But then, every once in a while, you get a seismic shift. And that's exactly what we're seeing inside the Supreme Court of India right now. This isn't just a minor adjustment. It's a full-on, top-to-bottom reset happening on so many different levels, which really makes you wonder.
What a question, right? It sounds almost impossible. But lucky for us, the Supreme Court of India is giving us a front-row seat. It's like a real-time case study. So we're going to break this whole reboot down into 3 key parts: tuning the judicial engine, guarding the institution itself, and maybe most importantly, redefining its mission.
All right, first up, the mechanics. It makes sense, doesn't it? Before you can change a big philosophy, you got to make sure the machine is actually running right. This first part of the reset is all about getting under the hood, tackling those infamous delays, and just making the court faster and a whole lot more efficient. So the first big change is a direct attack on the one thing the court can't make more of: time. They've rolled out a new standard operating procedure, or SOP. Now lawyers have to estimate how long they're going to talk, hand in a super concise 5-page note beforehand, and, this is the big one, actually stick to their time. It's all designed to get rid of those endless arguments and force everyone to be sharp and right to the point.
But this whole overhaul goes way, way deeper than that. To really get a sense of the scale here, just think about this one number, 26. That's how many brand new in-house committees the court just set up. This is not minor tinkering, folks. This is a complete restructuring of how the court manages itself. And the mission for these committees, it is absolutely massive. You've got sitting judges leading them, and they're tackling everything from the huge case backlog to bringing in new technology and even rethinking how public interest lawsuits are handled. The key idea here is decentralization. It's a classic management move, right? You spread out the work, you empower more people, and the whole system, in theory, gets faster and more responsive.
Okay, so while the engine is getting that much-needed tune-up, the court is also building up its walls, really reinforcing its independence and integrity from all the pressures of our very, very noisy modern world. This quote from Justice Suryakant just cuts right to the chase. The court is basically drawing a line in the sand. It's a powerful statement saying, hey, we will not be pushed around by the court of public opinion, especially not by the chaos that can happen on social media.
And Justice Kant really pinpointed a huge misunderstanding. See, when a judge fires tough questions at a lawyer, they're not showing their hand, they're stress testing the argument. It's a part of the process. But online, a 10-second clip of that can immediately be spun as, see, the judge is biased. The court is trying to explain that its process is about finding the truth through debate, not jumping the conclusion.
But it's not just about protecting yourself from the outside world. The real test of an institution is how it deals with a crisis from within. And recently, that discipline was put to the ultimate test when a lawyer literally threw an object in the courtroom while a case was being heard. Now, the court's reaction here was fascinating. The old-school traditional response would have been simple: bring down the hammer with contempt charges, punish the individual. But that is not what happened. Instead, the court chose a completely different path. It went for institutional reform, inviting the Bar Association to work with them to create new rules to make sure something like this could never, ever happen again. Someone called it a mature constitutional response, and that really nails it. This signals a huge change in mindset. It's this idea that the best way to guard the court's authority isn't just by punishing people, but by making the system itself stronger. It's about building better guardrails for everyone, not just dealing with the crashes after they happen. So this brings us to part 3, which might just be the most profound piece of this entire reset. Because beyond the procedures and the protections, what we're seeing is a real shift in philosophy, a move towards a more empathetic form of justice, especially for those who don't have a voice. Just listen to this statement. It came from a case about an elephant corridor down in the Nilgiris, and it is so revealing. The court isn't just weighing one human interest against another here. It is explicitly calling animals silent victims, saying their well-being has to be a central part of the decision. The choice couldn't have been more clear. On one side, you had commercial hotels and resorts. On the other, an ancient migration path for elephants. The court's observation sent a message that was impossible to miss. When private profit clashes with ecological survival, the scale has to tip towards protecting the environment and its non-human residents.
And this is not just a one-off thing. If you look closely, you can see this pattern of empathy emerging again and again in the court's rulings, especially in cases involving Justice Kant. A theme keeps popping up in its legal thinking, that justice has to be sensitive to suffering. It has to recognize power imbalances, whether that means ensuring a fair shake for a magistrate or showing incredible patience for an acid attack survivor caught in litigation for decades.
So, let's recap. We've got a 3-part reset, a faster engine, stronger walls, and a more empathetic mission. But there's one final crucial piece to this puzzle. It's the one that decides whether this whole transformation actually connects with the people. And that piece is transparency. The plan to live stream court hearings was hailed as this revolutionary step. The promise of open justice was just immense. But the reality, well, it hasn't quite lived up to the hype. Access has become inconsistent, sometimes it's there, sometimes it's not, and it often excludes the very people it was supposed to be for: journalists, the people involved in the cases, and the general public. This gap between the promise and the reality is now the biggest test of the court's commitment to being open. And that leaves us with the one big question that defines this entire transformation. The Supreme Court has done an incredible job tuning its engine for speed and fortifying its walls for independence. But for this great reset to truly stick, for it to be complete, those courtroom doors have to be swung wide open for everyone to see inside. Because the ultimate measure of justice, after all, isn't just how efficient it is or how strong it is, but how open it is to the people it serves.